This is from the Comptroller's Office, and these folks have done a very thorough investigation and research study and report not only on problems but also solutions as well, studying the gamut across the state. For those of you who have not seen it, we hope that you'll take a look at it because it is very, very thorough. Are you folks ready to present?
Yes, we are.
Please proceed.
Good morning, everyone. My name is Cassie Stinson, and I am a research analyst in the Office of Research and Education Accountability, or OREA, in the Comptroller's Office. Thank you for inviting us here today to share our findings from one of the reports that we did. So our office goal is to provide the General Assembly and other stakeholders with information to inform public policy. Our reports will come from various sources. Sometimes we'll have requests from the General Assembly. Sometimes we will generate reports internal to our office. This report itself was requested by multiple state legislators. Our report summarizes research about elder financial exploitation and considers Tennessee's approach to identifying, investigating, prosecuting, and convicting perpetrators. It also addresses stakeholders' views about potential gaps that remain in the system, as well as noting areas of progress. The report includes 5 conclusions and 9 policy options. This presentation will focus on our conclusions and will wrap up by outlining some of the policy options. So as we've discussed in other presentations, and as you all know, financial exploitation of the elderly is the wrongful or unauthorized use of assets, funds, or property of elderly individuals. In Tennessee, the agency most closely associated with issues concerning elderly abuse is APS, or the Adult Protective Services. Other agencies, though, and community actors play a role in protecting Tennessee's from elder financial exploitation, and those can include law enforcement, district attorneys, and financial institutions. This slide summarizes several state laws that the General Assembly has enacted since 2016. I'm not going to go through all of them, but in essence, these laws made changes including making financial exploitation of the elderly a standalone offense, authorizing financial institutions to report suspected financial exploitation, requiring district attorneys to create the Vulnerable Adult Protective Investigation Team, and requiring APS to provide copies of investigative files to district attorneys generals. More details about these laws can also be found in our full report, which is available online. Our first conclusion relates to APS, specifically the criteria for investigating reports. We found that those who work with the elderly and vulnerable adults express concerns about the criteria under which APS determines whether to investigate cases of elder financial exploitation, describing it as too narrow. APS criteria for investigating a report of financial exploitation is based in state law, which defines financial exploitation as the improper use by a caretaker of funds that have been paid by a government agency to an adult or to the caretaker for the use and care of the adult. In other words, alleged perpetrators must be a caretaker and the funds in question must be government funds for APS to investigate. The law governing Tennessee's provisions about APS has contained this definition since it was first passed in 1978. This chart here shows that in state fiscal year 2019, out of 3,824 reports of suspected elder financial exploitation received by APS, it screened out 756 reports that did not involve government funds. That represents about 20% of all reports. An additional 1,565 reports, representing about 41% of reports, did not meet APS's criteria for other reasons, such as it was not involving a caregiver or because the alleged victim did not qualify as vulnerable. In total, over 60% of reports did not meet APS's criteria and were not investigated by APS. Several stakeholders, including legislators, have expressed concerns about the provisions that limit APS's ability to investigate. In almost every interview OREA did, for this report, APS's criteria was described as too narrow, or stakeholders explained that they wish APS could investigate more of the reports. In 2017, DHS analyzed the impact of expanding the definition of financial exploitation to include non-governmental funds and acknowledged that it was open to the idea. However, expanding that criteria would increase the number of investigations that they would be required to conduct. DHS estimated that 25 new positions, which would include investigators, auditors, and attorneys, would be needed for an estimated cost of $2.2 million. In 2017, the 2017 report also indicated that if other revisions were made to the APS's criteria, additional expenditures would be required. To date, no legislative action has been taken to expand the capacity or scope of APS criteria. Our second conclusion is about the data limitations we encountered. There is no statewide system to track elder financial abuse cases in Tennessee. Without a statewide system, it is not possible to track cases when they are shared between state and local agencies. When asked to provide data about financial exploitation in Tennessee, several local and state agencies provided OREA with numbers about their caseloads. Many of the cases reviewed by OREA were shared between agencies, so the number of unique cases could not be identified. For example, a single case under the investigation by 3 organizations, say APS, TBI, and a district attorney's office. That would be counted as 3 cases in our overall research. Since it is not currently possible to connect a case across multiple organizations, a single case could be counted multiple times. So this chart here shows the information and data that we were able to compile throughout our research. As you can see, the black boxes on the chart indicate a lack of available data. There are also several caveats for the data that we did receive. For example, the Administrative Office of Courts, AOC, can track prosecutions by TCA code. This allows tracking of all cases under the Elderly and Vulnerable Adult Protection Act. Victims' ages are not tracked, though, so the data cannot differentiate between cases which the victim is a younger vulnerable adult and those in which the victim is an elderly person. In addition, prosecutors can choose not to charge exploiters under the Elderly and Vulnerable Adult Protection Act and instead charge them with theft. Without tracking the victim age, cases involving an elderly victim cannot be identified. In addition to case data, we were interested in estimating financial losses to victims and the state. Only one agency was able to consistently estimate the financial loss to victims, and that was the Tennessee Department of Commerce and Insurance. They had decided to track it internally in the form of an Excel file that they were able to provide to us. For agencies with larger caseloads, though, this may not be a possible way of tracking their cases. Many agencies explained that determining the cost of all their cases would require investigators to comb through case notes and files. Due to these data limitations, OREA was unable to estimate the prevalence and cost of elder financial abuse in Tennessee. Our next conclusion is that Tennessee's approach to protect elderly adults from financial exploitation is made up of a patchwork of local and state entities. Their effectiveness in tackling this growing issue, however, is unknown due to the data limitations as described earlier. Before I discuss why we call this a patchwork approach and why we were unable to assess its effectiveness, I want to first outline the evidence we found that this is a growing issue all the same. APS was able to provide OREA with report and allegation data since 2015, which is shown here on the chart. Sizable increases in elder financial exploitation reports made to APS over the last few years suggest that elder abuse is increasing in Tennessee, or that reporters have become more aware, or a combination of both. From 2015 to 2019, reports of financial exploitation increased by about 87%, as you can see here with the blue line. At the same time, the number of investigations by APS has not increased. This is likely because APS's criteria for financial exploitation, defined by state law, effectively limits the number of assigned investigations, keeping them to an amount that current resources and staffing levels can address. While state law effectively limits APS's investigative scope, financial institutions like banks and credit unions have increased the reporting of suspected financial exploitation. This graph shows the increase in reports to APS from financial institutions from 2015 to 2019. This graph and the one before suggests that elder abuse is indeed a growing issue and that APS is screening out more cases as a result. Although a number of reports from financial institutions has increased, many of those reports are screened out by APS. There are several reasons for this, but one is that those who work at financial institutions are less likely than other types of reporters, such as family members, to know the relationship between the potential victim and the perpetrator. If the report does not state that the potential exploitation was committed by a caregiver, APS is more likely to screen it out. Financial institutions are also more likely to report online or through fax. Reports received via these means often do not provide the same level of detail that a phone conversation can provide, and therefore they are more likely to be screened out than those received over the phone. Although intake workers at APS are expected to follow up by phone on reports submitted online and via fax, they are sometimes unable to reach the original reporter. APS intake workers may also not be able to follow up on each online and faxed report, especially during the summer months when reports of abuse increase and intake workers are at full capacity with phone calls. APS has not increased the number of intake workers since 2015, despite the increase in the reports. If these reports and staffing trends continue, intake workers will have less capacity to follow up on the online and the fax reports. After APS screens out reports that do not meet its criteria for investigation, the agency forwards them to other entities as appropriate. This includes other state agencies, and they may investigate the reports further. Between 2015 and 2019, the number of reports forwarded to other entities increased. For example, district attorneys received 50 times more reports from APS in 2019 than they did in 2015. While the number sent to local police nearly doubled. This has caused these entities, which are located throughout the states, to become increasingly responsible for combating elder financial abuse, leading us to call Tennessee's system a patchwork approach. As explained earlier, it is not possible to track cases where they are shared between state and local agencies, making it difficult to assess whether the current system to protect elderly adults is able to handle this growing problem. OREA requested a number of prosecutions and convictions from each of the 31 judicial districts for cases involving elderly financial exploitation between the years of 2015 to 2019. The ability for judicial districts to track case data is inconsistent across the state, and there is no state system for the districts to input cases. According to case data, in some districts that tracked it, the numbers of prosecution of elder financial exploitation appears to be increasing as districts become more familiar with the new laws. One district attorney general estimated that it would take 5 years from when the new laws became effective to determine their full effect. In 2019, OREA's survey of judicial districts, several cited a need for statewide database that would allow judicial districts to track cases and outcomes. This data, if tracked, could help show legislators and other stakeholders the effects of new laws. The Tennessee District Attorneys General Conference told OREA that it worked with APS during 2017 and 2018 to create a database for elder abuse cases. The database was almost completed, but ultimately not implemented due to funding issues. The estimated cost of the database was about $63,000, according to APS, with the annual estimated cost of $14,000 for technology, staff, and support resources. District attorneys say that financial exploitations cases are particularly complex, challenging, and resource-intensive. Many cited a lack of access to staff with expertise in tracking assets and resource-intensive. Many cited a lack of access to staff with expertise in tracking assets and forensics accounting, which can hinder investigations of financial wrongdoing. Some districts lack a significant number of criminal investigators, and some must rely heavily on local law enforcement for investigations. Some said that law enforcement officers often lack the proper training to conduct thorough investigations in complex elder financial exploitation cases. In the information submitted to OREA from the 19 of the state's 31 judicial districts, district attorneys indicated that there is a need for additional training for law enforcement, district attorneys, and others concerning the investigation and prosecution of elder financial exploitation and all types of elder abuse cases. One district attorney noted that training district attorneys and law enforcement together is especially beneficial. So for our policy considerations, from our research, we created a list of 6 policy options that the General Assembly may wish to consider. They're summarized here, and there are more details in our full report. These options include expanding APS criteria and creating additional intake staff positions for APS, revising state law concerning the confidentiality of reporters to APS, funding additional APS staff positions for district attorney generals, and funding and mandating improvements to data collection and elderly abuse cases. So those are all outlined in our report, and there are more details on those suggestions as well.
Thank you very much for that report. Are there any questions or comments from the task force? If, Renee, you are representative of APS, and I don't want to put you on the spot. This law has not changed since 1976. The comptroller's looking into this. We hear a lot of times, and it's by virtue of the law. It's not discretionary, obviously. But one of the issues that you all raised that we're all familiar with is if it doesn't involve the caretaker and it's not government funding, we really don't investigate beyond that, because by law, those are the requirements. If we were to expand beyond that, is APS prepared at this time, and you may not be, to discuss maybe what that might look like if we were to change that? Yes, ma'am, if you don't mind.
Okay, sorry. I think we're certainly open to the conversation. We did a study back in, 2017, but we're going to struggle with some of the same things that the law enforcement and the DAs are. We're social workers. We're not forensic accountants, so we're going to have those type positions. We're also going to have the resources, including your agency, for example. So if we found someone who was being scammed that needed a decision maker, we can't control the money. Our process would be to make a referral over to your public guardian program. And, sometimes those are already, at cap. So I think it seems like it's above just expanding our definition from my point of view. Now, I'm not speaking for my department, but from my point of view, I think we really need to look to see where are the gaps and what is the expectation. I can't recover money under our current statute. So if someone is getting exploited, I can't file a lawsuit to get that money back. But I think there's just a lot of moving pieces there, and we're certainly not opposed to discussing that. I just like to make sure that when we do something, let's make sure that it's effective, if that makes sense, because I do know right now we do have a lot of moving parts in that process.
I will say that the APS has been very helpful to us. We operate a CREVA program, which basically helps to compensate and get people back right when they have been victimized by a crime that is for elderly folks. And one of the things that has been helpful to our AAADs is having access to the 1215s forms that you guys complete on your investigations, and us identifying, I guess, or being able to ascertain whether or not if a crime has in fact been committed. And it sounds like the DAs are taking these 1215s too. I don't know. General Clark had talked a little bit about that. I don't know if he's around here any longer. Someone else may want to speak to it. I don't know if we're reviewing those in their entirety and extracting information from that for purposes of prosecution. That kind of thing. It may be interesting for the audience to know more about that. General Clark, if you'd like to speak to it.
Yes, sir. All the 1215s are forwarded to the DA.
General Clark, if you don't mind, if you could come up to the podium here and hit the talk button. We'll make sure that for our folks in the audience, they can hear exactly what you're saying. If you could just state your name, who you're with, and respond to the question, please.
Yes, sir. All of the 1215s are received by each DA in their district from APS. All of those are reviewed. Ideally, they're reviewed immediately and then acted on. We found that to be the best model because time is so critical. Ultimately, they are all the subject of a discussion during the VAPIT meeting. So each 1215 is reviewed as an individual case. But of course, those VAPIT meetings on average are going to be 15 days after the initial 1215 report because the VAPITs are meeting once each month. So we really need quick action within the DA's office and in law enforcement to achieve ideal results. And in our case, minutes matter. We want to get to that bank while that person is still in the lobby or in the drive-thru.
Thank you, General Clark. Thank you, Renee with APS. Thank you also with the Comptroller's Office. Are there any further questions or comments from the task force? Director Rouse.
Yeah, just one comment on the policy options slide on the piece on urging the Medicaid Fraud Control Division to investigate Medicaid outside of institutional settings. That just changed, and so we do have that authority now.
Thank you, Director Rouse. Are there any further questions or comments? Senator?
Just one question or comment. I heard earlier from a couple of presenters that they were having cooperation with the partners involved in all this, but if we expand the law to cover monies that are not governmental, are those partners going to be participating in it? Because we're getting into personal accounts. I don't know who I'm directing that to, but maybe you, Director Dunn.
Yeah, well, Senator, we'll open the floor up here for anyone who would like to partake. I think obviously we cross the lines between law enforcement there and also prevention, right? Between those who want to build the case, between those who want to make the arrest, and between those who want to prevent, and to those who are trying to prevent any sort of elder abuse. So most certainly, I suppose if we expanded it, we would get into that. These partnerships are not going away. There's jurisdictional issues that, frankly, I don't think we can dissolve the lines. I mean, the DAs have certain jurisdictional powers that, frankly, are inherently theirs that cannot be crossed over, as does law enforcement. So it may require additional study, but it is, I think, one of the frustrations. Again, it's by virtue of the law, but our system is not as robust as perhaps maybe some other states are in that regard. But that is a bit outside of my wheelhouse, but I'm happy to have further conversations. Yes, ma'am. Renee, please.
Yeah, I could just speak a little bit to that. I do think, I mean, in order for us to be successful, it's going to have to be, because we do administrative investigations. We don't do criminal investigations. So, I mean, I'm not sure, and there's some DAs that could speak to that, but I haven't had a DA take our administrative investigation and be able to prosecute on it. I mean, we don't read the alleged perpetrators, their rights, that kind of thing. So I do think there's going to have to be, if we're talking about, successfully prosecuting and recouping some money, there's going to have to be that collaboration.
Thank you for that, Senator. General Z.
Let me say, it's nice to meet you, Senator Rose. I've heard some wonderful things about you.
Was that Powers or Rose you heard about?
Rose. That was Rose. I got the name right.
The best looking one, I think, maybe.
Let me say from my perspective, I've been fortunate to be involved since 2014 on the first task force. And my eyes were opened with everything that's going on. I didn't know what a 1215 was. So since that time, we've come a long way. One of the things I think that we have developed is this relationship with APS, in where our goal, first and foremost, is to protect that individual. It's not necessarily about prosecuting a case. It's making sure they're safe. That is one of the advantages I do see if we expand that criteria that we will have. It's getting someone in that home, because when we know we got APS that's going to go out there immediately, they're going to help us make sure that that person is safe. So that's one of the things I think expanding the criteria would help us, is to get into that home faster. because that sometimes slows our response time down. And as you've heard on multiple occasions today, response time is everything. Just as it is with saving children, it's the same way with saving elderly people. Whether, if their money's being taken, oftentimes their food is being withheld. So I do think that that would be a benefit to this.
Thank you, General Z. That's a good point. It gets back to what Director Rouse was talking about, and maybe there is a best interest of the child type situation for an adult that might give law enforcement or APS or the proper authority that calls sufficient to go ahead and intervene, and where there's a situation that may be imminent. That's something I think, to look into. Law enforcement is better subject matter expert on that than I would be, but that certainly makes sense, because that's the fear, Senator. We end up in these situations. It's like these folks in these residential settings. They, I think, a lot of times are well-intentioned, some of them not always, though, but when you get these people in this context where they have no other family, they have no resources, they're vulnerable, and they do get preyed on. And frankly, the ones that we're finding out about are only the ones that we're finding out about. There's no telling across 95 counties how much of this kind of exploitation is going on with these vulnerable adults. So we definitely have to do better, Senator, and I appreciate your willingness to help us do so, and I appreciate everybody's willingness here to further engage in this as we go forward. Are there any further questions or comments from the task force here, of the comptroller or otherwise?
Well, thank you all for having us and greatly appreciate your time.
Thank you, ma'am.